Bonjour, my name is Laura Newton. I'm the Family Services Program Director at the Minneapolis American Indian Center. And I'm really excited to see a really full room today. And I know we've got a lot of folks joining us online, so that's great as well. I'm going to just quickly go over a few little items here that we need to know before we get started. And then I just want to acknowledge that this is ICWA's 44th anniversary. And also I'd like to take a moment to just acknowledge that we are on our ancestors' land, the traditional land of the Dakota and the Anishinaabe people. And I'd like to welcome you all to this nice space here at Minnesota Indian Women's Resource Center. They've graciously allowed the space this evening. And now I would like to introduce Charlene Dan, who will then introduce her family, who's so nicely agreed to sing us a song tonight to start us off in a good way.
Bonjour, relatives. Didn't I tell you I like the mic? I knew that Laura would do a good job of introducing them, but I wanted to tell you a little something. And that is that those of us that have worked for many years in the ICWA field, we sometimes get tired, we sometimes get burned out, we sometimes get a little depressed and feeling a little anxious about where things are going, especially with the state of things today. But I would like for you, as you sit down and get ready to enter the next phase of this meeting, to kind of think about the evident truth. The evident truth you're going to see of ICWA in just a few minutes as you see this wonderful family. Even if I wasn't related to them, I'd like them. Wonderful families display some of their talents and give us their good wishes in the form of a prayer song. So please, if you can come forward, Opachi. I only call him that when he's in trouble. Opachi, his wife Desiree, and little baby Hope. By the way, this little guy has 75,000 Instagram followers. Not the big guy, the small guy.
Miigwech ni mama. Buju, then end away money do. Margiana quad indigenous cause, Opie Davidu, Minawa and Digo. Owasasi and do them, the Gaiganing and Dunjiba.
Bonjour, Mecca, Mana, Suffixes, Sucrination, Itaboa, Crination, or short.
Dan say Desiree Denimina Sigasun for Pixies Octinia. Hello, my name is Desiree Denemy, and we are happy to be here to open up your event.
Just a few quick words before we begin here. I would like to just say thank you to each and every one of you for all the work that you do. I am a child of someone who's worked with ICWA for many years, and I was witness to all the hard work that goes into what you guys do. You know, all the after hours, the extra things that you guys do. You go about the things that you carry along with you, and I know it's hard work. And on behalf of me and my family, I would just like to say miigwech to each and every one of you for all the hard work that you do. We were asked to come here and start you guys off in the best way possible that we know. And we're going to do that as a song. And I would like to just, leave this with you guys, the work that you do for our Indian families. I hope that when you see us as a family singing together, that you understand that's what goes along with what you guys do. We're possible because of what you guys do. And there are so many Indian families out there that I know are in the same boat. So thank you guys once again.
miigwech. Oh, I can't thank you enough. That was so beautiful. Thank you so much for coming and starting us off in a good way. Thank you also, Charlene, one of my teachers. It's always wonderful to have her here to start us off. All right, we're going to go ahead and get started. Okay, we're going to start first with Shannon Smith and Karl Nastrom. Thank you. I'm glad I got it right. I wasn't sure. Who are going to do an overview of the Brackeen versus Haaland case. So I'm going to turn it over to them and let them introduce themselves further and give you an overview. Thank you.
Okay, thank you. Can everybody hear me in the back? Is this okay? All right, so my name is Karl Nastrom, and I work at the ICWA Law Center. And I'm going to start off this part of the presentation, which is called ICWA Under Attack. And ICWA has been under attack for a long time, but in this specific case, it's been under attack since 2017. In 2017, 3 individual families and 3 states filed suit in federal court in Texas, asking the court to declare ICWA unconstitutional, to say that ICWA is illegal. One of those families was the Brackeen family. So when we refer to the Brackeen case, that's where the case got its name from. Another of the families was the Clifford family, who is from Minnesota, and I'll talk about them a bit more later. But the United States was they were the ones that were sued first because ICWA was a federal statute. Specifically, the Secretary of Interior was sued. So right now, Deb Haaland is the defendant in the case, or the responding party. So Brackeen versus Haaland is the case that's at the Supreme Court. And almost immediately, 3 tribes asked to join the case to provide their perspective on the case, and the court allowed that. So for 4 years, this case went through the lower courts with the United States and eventually 4 tribes defending ICWA, and 3 families and 3 states attacking ICWA. And at the end of those 4 years, there was a split decision, basically. There was the appeals court that oversees Texas, came out and said that some of this is unconstitutional, some of it is constitutional. They wrote a 300 and some page opinion, which is one of the longest appellate opinions ever written. It basically says a big mess. Everyone who looked at it said this is a big mess. Lawyers knew right away that the Supreme Court would probably take the case to unsort the mess, and that's what happened. The Supreme Court decided to take this case, Brackeen versus Haaland, to unsort the mess and decide whether ICWA is constitutional. Now, within the case, within ICWA being unconstitutional or not, that the Supreme Court has agreed to hear, there are several parts of what the court is going to do, several questions they're going to answer. The biggest overall question is they're going to decide whether the individual families in the state of Texas are correct that ICWA is really based on race, that it's not a political question, that it's a racial question, and therefore that ICWA is unconstitutional as racial discrimination. That's the biggest overall question that they're being asked to answer, and that would have huge implications for many areas of law, beyond Indian law even, that we're not going to go into tonight. Another question they're being asked to decide is whether the state courts are unconstitutionally being asked to give active efforts in ICWA cases, which is the current standard under the federal law. The families in Texas have asked the court to decide that that's unconstitutional. And then they've been asked to find that the placement preferences under ICWA, which say that the tribes can vary the placement preferences that the state law would otherwise have in place, the families in Texas have asked the Supreme Court to say that that's unconstitutional. So that's a lot. Each of those could be, a long presentation alone, but all of that is up in the air right now because of the Supreme Court's decision to take this case. So that's the attack. It's a big attack. it could do away with ICWA altogether. That's the goal of the lawyers and the parties that have been trying to attack ICWA for a long time. That's their goal, is to get rid of ICWA. And so that's what's at stake. As far as what's going on to oppose the attack, I'm going to talk just briefly about a couple things. One, I'm going to mention that, of course, the United States and the tribes who are parties have filed, they've been fighting back against this attack the entire time. The United States is very vigorously defending ICWA in federal court, and the tribes are very vigorously defending ICWA. There are 21 entities that filed briefs to the court, friend of the court, or amicus briefs in the U.S. Supreme Court, giving the court additional reasons why ICWA should be upheld. One of those briefs that I'll mention first was filed by members of Congress. Not all members of Congress, but some members of Congress. 87 members of Congress filed a brief, and 4 of the members of Minnesota's congressional delegation signed on to that brief. Both senators, Amy Klobuchar and Tina, signed the brief, and then Representative Angie Craig signed the brief, and Representative Betty McCollum signed the brief. So 4 of Minnesota's congressional delegation members signed on to this brief. So that's one thing that people from Minnesota have done. The Attorney General signed on to a brief, the Minnesota Attorney General signed on to a brief that was written by the Attorney General in California. 23 other Attorneys General signed on to that brief. And then a little closer to home, we at the Law Center, in partnership with a law firm out of California, wrote a friend of the court brief for a woman named Robin Bradshaw, who is, her granddaughter was fostered by the Cliffords, who are one of the 3 families who are a part of this attack on ICWA. And because of the way that this attack on ICWA came about in federal court, Robin Bradshaw and White Earth had intervened in the case as well, were litigating against the Cliffords in Minnesota State Court. Litigation went on in various ways from 2014 into 2020. In 2017, the same year that this federal case started down in Texas, White Earth came in and actively opposed the Cliffords' attempts to adopt Ms. Bradshaw's granddaughter. So there were 2 litigations going on, one in Texas that's now before the United States Supreme Court, and one in Minnesota that was happening under Minnesota state law, under MIFPA and ICWA as applied in Minnesota. The reason that we wrote the brief is that all of the information that was happening in federal court in Texas, then at the appeals court, and then the Supreme Court was done without Robin Bradshaw's participation. But lawyers for the Cliffords were sharing facts with the federal courts that were not true. And they were disparaging Robin Bradshaw in ways that were not true. And so it was a case where Robin Bradshaw, who the law represented in the Minnesota litigation, she did not have a voice in this very important federal litigation. So when the Supreme Court took the case, this was the first time that Robin Bradshaw had a chance to have her voice heard. And so we wrote a brief to share her story. And let's see. And basically her story was that she was with her daughter, was living with her when she was pregnant with her granddaughter. And Robin was present with her granddaughter in part of her life from the time that her granddaughter was born. So this is a very involved family. There was a removal through Child Protection Service. The same day that Robin's granddaughter was removed from her mother's care, Robin called CPS and said, "I'm the grandmother and I've been raising my granddaughter and I'm ready to take her." And CPS said, "No, you can't have her." Robin had some disqualifiers on her record that the Minnesota State Court later found the county should have told her that she could clear those disqualifiers. And they should have also helped her clear those disqualifiers. And the county didn't do either of those things. So because of that, because the county just said no, for 3.5 years, Robin Bradshaw's granddaughter was in foster care. And her final foster care placement was with the Cliffords. And the Cliffords, although they got the same admonition that every foster parent gets, that this is not a guarantee that you're going to be able to adopt, the Cliffords were led to believe by parties, by people who should have known better, that they would be able to adopt. It was all but a done deal. So they formed an expectation that they would be able to adopt. So when White Earth intervened and the case became an ICWA case, the Clifford's adoption of Robin Bradshaw's granddaughter was not done, no paperwork had been filed, but they had an expectation that they would be able to adopt. So on the basis of this expectation, which they then said was frustrated by ICWA, the Cliffords complained to Minnesota State Court, and they complained in Texas federal court that they had been hung out to dry by ICWA. And that was the basis, and that still is the basis of their complaint. If anybody wants to go read all of the Supreme Court filings, that's still what they say. The Minnesota State Court held a 5-day trial. And at the end of that 5-day trial, they said that under every possible standard, even leaving aside ICWA, even just applying Minnesota law, Robin Bradshaw was the proper person to raise her granddaughter because she's family. And so we wrote a brief to share that information with the court. And with these things in a Supreme Court case, there's only one number that matters, it's 5. That's the number of votes that it takes to win. So we don't know if our brief will contribute to one of the justices voting in favor of upholding ICWA, but it was the part that we could play. And so that's just a little bit of a brief overview about the brief that we did and how it fits in with the overall defense against this attack on ICWA. And now I'm gonna turn it over to Shannon.
Thank you. It's good to see so many of you and so many familiar faces. And in some ways, it's really hard to be here because it feels like as I look around the room and listening to the song, like how many people have been doing this for so long and how important we know this work is and how important like Robin's story is, that why would this be in doubt? And so in that sense, it's hard because without where we're at, we know the work is hard enough, right? And if ICWA doesn't exist, what would that look like? The things that, when I think about active efforts, I feel like active efforts is really the heart of ICWA. And the idea that for some reason that is being used in a way to say that it's hurting children, when in reality, I truly believe like that's the gold standard of the work that we should be happening for all families and for all children. And so the opportunity to come together and I thank you for seeing so many faces, because I look around, I'm like, oh my gosh, that's someone I've known for a long time, and I think Charlene, our first case, she was on one of my very first cases many years ago. I think one of the things that that is really hard is that what's going on in the Supreme Court matters to us for a lot of reasons, but we also know that, for example, in Robin's case, the judge that heard the voice of Robin, that heard the voice of the Cliffords, the judge that heard the voice of a guardian ad litem, the judge that heard the voice of tribal elders and tribal members, is the judge that said it's absolutely best for Robin's granddaughter to be with her. The Texas courts that were relying solely on statements by attorneys, that were relying on statements without the voice of any of the people that were so impacted by this, is the court that said, this isn't a process that I agree with, right? So it feels very in some sense, very disingenuous and very just harsh, because we know how important the voice is of all of those that we work with every single day, the voice of everyone in this room. So I think one of the things that we know is that regardless of what happens at the Supreme Court level, yes, it will have an impact. And yes, it's something to fight for ICWA. And yes, it's something to have conversations and talk to everyone about how important it is in our work every single day. That there's, hundreds of cases every day in Minnesota that ICWA has a positive impact on. But we also know that there's things that we can do here that, regardless of what is decided, that how we do our work, how we form our policy can continue, because it's more about those connections and that work done in a way. So one of the things, and when I'm done, I'm going to turn it over to Rebecca McConkey-Greene. But one of the things that we know is that there's other ways where policy and law is formed, and other ways in which the work that we do is impacted. So for example, in Minnesota, we have the Tribal State Agreement. The Tribal State Agreement is something that is a reflection of collaboration and commitment of all 11 tribes geographically located in Minnesota, and the Minnesota Department of Human Service saying, look, we have an opportunity to do this in the best way for children. And in that agreement, the ideas of what is in the best interest of an Indian child, recognizing that children are sacred and close to the Creator, and that they're the very future. So things like keeping families connected, making sure that children are connected to their community, making sure that children, the entirety of their identity is honored and protected. That is all language that is part of this agreement. And regardless of what happens, on a federal level, that is something that we hold true in Minnesota. We also have, and Rebecca will focus on how to even make this stronger, but we have the Minnesota Indian Family Preservation Act. And the Minnesota Indian Family Preservation Act is a state law that tells us how we can do this work and how we need to do this work. So defining things like active efforts. And I think when we think of ICWA as a gold standard of social work and a gold standard of child welfare practice, active efforts is really at the cornerstone of that. How can we be responsive to families? We don't want to react to families, but how can we be responsive to who they are, what they need, and what's happening to them? Active efforts allows us to do that and tells us we need to do that. ICWA also provides a higher standard for termination of parental rights beyond a reasonable doubt. And that's something that, incorporating that kind of language into state law. If a termination of parental rights is going to happen, certainly we want to make sure that that very highest standard is in place to ensure that we're protecting families. And so there's a lot of work that we can continue to do. So if there's hope in all of this, I think this room is it, right? We have people that come and continue to come and continue to use their voices to make sure that, that yes, the law requires it to do it, but that's not why we're doing it. I think everyone here is doing it because we know that it's best. And that if the child welfare system doesn't work in a way to honor children and to honor families, then we're failing. And we know that we can do this in a way. So even though there's a lot at stake, and not to in any way take away the importance, I think one of the greatest honors, and I've had an opportunity to work with a lot of families, but to, hear and know someone like Robin, who showed up over and over and over again when everything systematically was telling her that you can't do this, and ultimately she prevailed. And she's an inspiration, but I think all of us know that there's inspirations every single day that we need. Yes, a question.
Well, thank you so much for letting me speak. I was wondering if you could speak about how Robin, I think you said 3 years, it took her to keep trying and trying, but and I don't want to bring any negativity to the room. People who know me know that I talk about lateral violence. People know that I talk about lateral oppression as being the root issue of things and seeing that we need to address that. But we can do these type of things in this type of work. I'm a former foster care licensed worker as my last position. So I very much understand what's needed, that we need foster parents, healthy foster parents to be able to do this work. But I'm wondering if you could speak a little bit about, if you can, for Robin, about how she tried to go to different organizations. She tried and tried and tried.
Yep, absolutely.
Talk about that.
Yeah, absolutely. So I mean, part of Robin's story, and I think it's the story of many people. But she went to every organization. She went to court, she went to the county, she went to.
Shannon, I'm so sorry could we just maybe repeat the question, because I think online they can't hear the person in the room.
Yeah.
So I'm sorry to interrupt.
Yeah, no worries at all. So the question was, if I could speak to Robin's efforts over 3 years, going to different organizations and continuing, and kind of her persistence. And one of the difficult pieces of kind of, and I think a testament to why what is needed, is there was a period of time, and during those 3 years, where Robin's case was not considered an ICWA case. And that, because of that, some of the resources that may have been available, some of the responses that may have been available, weren't put in place. And so it was a long period of time where she was fighting, because she knew who she was, she knew who her family was, she knew what, who her granddaughter was, but there was a significant period of time where her case, for legal reasons, wasn't considered an ICWA case. And because of that, some of the people involved, some of the kind of different situations, she wasn't afforded some of the same opportunities that she was, and some of the same kind of resources that were available at the time that it was determined that it was an ICWA case. And there's a lot of legal complexities kind of why that happened, but it definitely changed things significantly when there was a recognition, and White Earth stepped in and intervened. They were instrumental in regards to making sure that at that time things moved forward in a way to really honor her connection as a tribal connection, but then also her connection to her granddaughter.
Okay, that's another question too as well. How do you guys who like say a parent is enrolled, but the children can't be enrolled because they're not going enough blood? But like a parent that comes to you and say, no, we can't take the case because our child's not recognized. Then we have to go to court and we have to fight, trying to fight to keep our children, but they were ripped away, because I have experienced that myself, along with all the families. Because the tribe will not recognize the child of the descendant of the blood. And it takes years and years and years until somebody else has them. And they go to a family, and the veteran and Litem don't hear the children. So how do you guys take your guys' cases when people are coming to you and asking for help?
Yeah, absolutely. So one of the things in regards to tribal sovereignty is tribes are the ones who determine who is a member or who is eligible. So ultimately, in regards to the legal piece of it, we, as far as the court process, it's really determined on the tribes. I mean, the tribe's voice in regards to who is a member or eligible for membership is ultimately what is relied on. In regards to the child welfare process, as far as representation and working with people, and that's really one of the reasons, in regards to the gold standard of ICWA and active efforts and family connections, because I think we could all do a whole lot better in regards to how families' voice is brought forward in the child welfare system as a whole. But specifically for the legal piece of ICWA, it's dependent and on tribes, recognizing who is a member or eligible.
So the more likely the different flavors of will have higher blood content, right?
You know, in regards, yeah, in regards to tribes, I can't, I mean, I don't, every tribe as a sovereign nation has the ability to make the determination how they do. So I don't want to, I mean, in any way infer that I know kind of what the process is, because ultimately they're the ones that get to decide.
That the children are warned of the county. If they're not, if the tribes don't step out, is that true, that the children are warned of the county?
I get,
I'm asking them so that we can get more aware.
yeah, no, yeah, I don't know if I exactly understand your question.
If a child is in foster care, say, head of the county and they fill out, there's nobody there, no family members, the tribe isn't available or able to take them in, then they are warned of the county.
Yeah, what happened, there's a transfer of custody to the county if they are out of the care of the parent. Is that, I think that is that maybe what you're referring to. So if for example, there is a parent that's involved, and maybe it's a non-ICWA case and a child is placed out of home, then that child, when they're placed out of home, temporary or custody is transferred to the county on a temporary basis. Yeah.
Can I ask you a quick question?
Yes.
So from parent of a child that the open chip stays on, if the parent is enrolled, then isn't the child protected under the law?
I mean, the tribe ultimately would make that determination, but if the child's enrolled,
Okay, for instance, newborn baby is not enrolled.
but if the child's eligible and the tribe recognizes, yes. Yes,
Does the tribe has to?
the tribe would receive notice and then would respond to that. Oh, I'm sorry.
That's okay. It's hard when we're on Zoom and in person, so apologize. I think the last question was about if there was a newborn child who has, not been enrolled yet. I guess who determines that that's an ICWA case, and I'll let you reiterate what you just said.
Yeah, so if there's a newborn child and a child is not enrolled, but the child, there's reason to believe that the child may be eligible or maybe an Indian child, then notice would go to the tribe, and then the tribe, even if the child's not enrolled, but eligible to be enrolled or eligible for membership, then that case would be an ICWA case.
So would that still mean then to if the parent of the child is not enrolled?
That is correct in Minnesota.
But the grandparent.
Ultimately, it would be up to the tribe, as long as the child is eligible for membership, yes.
So what is being said here is there's a question about whether if a child is not enrolled, but the parent is, what in Minnesota happens in that particular setting, and that again goes back to the tribe. Each tribe is able to individually determine who is eligible based on their own tribal codes and their own codes and their policies. So that's one thing to remember. There's lots and lots of tribes all across the United States, and each one of them do it differently. So it is hard because it can be very confusing. So if you hear a story from one person, it might not be the same because each tribe is very different. We actually do have to start moving on, but we'll give you a minute for any last comments. And I want to let you know, if you have questions and we don't get to you, please write them down, because we're going to have a Q&A time. And so we'll move on to the next person, but we will still try to get to your questions in just a little while.
So I will go ahead and turn it over to Rebecca. I just want to say that a lot of this, there can be a lot of really specific questions, and sometimes it can be very confusing. never feel like you need to know the answer. It's really important you ask, or if you have questions about, the possibility of ICWA eligibility, ask and provide the information that you do have. I would hate for anyone not to share because they don't feel like they know the answer. Provide the information you have. And it's the responsibility of someone else to make sure then that the answer is found. So thank you all, and I will turn it over to Rebecca.
Thank you so much for asking me to participate in this event. I'm very honored to be asked to be here, and I'm really honored by the fact that we have so many people present and paying attention to these issues as we go forward. This is kind of a difficult and a little bit scary of a time, and so I'm glad that there's such a large community that cares and is here willing to work on these issues. So I'm gonna kind of jump right in. As Shannon mentioned, I, along with Cindi Miller, who is up on the stage, have been working with a group of people, tribal attorneys and tribal social service directors and the ICWA Law Center and the ICWA Guardian Ad Litem program to try to amend MIFPA. And I'm gonna see if I can get my PowerPoint going. So I think Shannon touched on a little bit that child welfare in the state of Minnesota has kind of three different realms that we're dealing with. And on a federal level, there is the Indian Child Welfare Act and the BIA regulations. And those apply in all 50 states to all Indian children in those states. And both of those, both ICWA and the BIA regulations, are somewhat at issue in this lawsuit that is going forward to the US Supreme Court. Then over on the right-hand side, we have Minnesota statutes, including 260C, which is the Child Protection Statute, and then the Minnesota Indian Family Preservation Act. And that's what I'm going to be talking with you about today as well. Also in Minnesota, though, we have tribes that have tribal courts that hear child protection cases, and they all have their own codes. And so it's important to remember that that's a process for protecting children and families as well, and that they're there and in this picture too. So the Haaland v. Brackeen case is going to be heard on November 9th. We're expecting to see a decision next summer. And as mentioned, I think there are 7 individuals, I think 3 couples and 1 individual person, and then 3 states that were the petitioners who brought this all about. The petitioners, I summarized this into kind of 3 main arguments, and they're a lot more detailed than this, but I think for our purposes today, there is an equal protection challenge that is basically saying that the Indian Child Welfare Act is based on race instead of political status. And then there is a challenge that is saying that the passage of ICWA exceeded the powers that Congress had, that Congress didn't have the ability to pass the law. And then finally, that the Indian Child Welfare Act commandeers or bosses around, if you would, and for a more casual way of saying it, state courts and state agencies. And so those are kind of the 3 types of challenges that they're bringing. So to talk a little bit about the Minnesota Indian Family Preservation Act, it was originally passed in 1985. It's been amended over time. There was some significant amendments that happened back in 2017, and those were to put into Minnesota law parts of the tribal state agreement that tribes in the state had relied upon, but that weren't law. And so we couldn't necessarily argue those if we needed to in appeals and if those came under challenge. The Minnesota Indian Family Preservation Act, when it was drafted and passed, was intended to supplement the Indian Child Welfare Act and not stand necessarily as a completely independent statute. So one of the problems that we'll have is that if ICWA is found unconstitutional for any of the reasons, the current version of MIFPA will be very difficult. One of them is that, first of all, it doesn't have a severability clause in it. Often statutes will have clauses that say something to the effect of that if part of this law is found to be unconstitutional, the rest of it stands, and we don't have that currently in MIFPA, so that's one of the things that we need to add. And then second, again, because it is a supplemental statute, it has some areas that are a little bit difficult if we lose ICWA. For example, the part of MIFPA talks about deviating or allowing placements away from the placement preferences in ICWA, but doesn't actually define placement preferences. So if we lose ICWA, then that portion of the statute wouldn't be referencing anything. So there's a need to kind of fix some of this and make sure that we have everything that we need in Minnesota law. So we're hoping that revising MIFPA will help if the Supreme Court were to find, well, okay, first of all, we all hope, of course, that none of this is necessary and that next summer we're going to get an order that says that ICWA stands and is good law and continues to protect Indian families now and in the future. But if we lose ICWA or parts of ICWA because of either the challenges based on the Commerce Clause or saying that Congress does not have the authority to have passed the law, or based on commandeering challenges, which is when the federal law improperly tells state agencies or state courts what to do, that if we have passed the provisions in ICWA into Minnesota law, it will instead be coming from an authority, the state of Minnesota, that does have the ability to legislate in Minnesota and tell Minnesota state agencies and state courts what they need to do to protect Indian families. So that's what we're helping to do and hoping will help in the future. Some other things that might be very helpful to do is, as Shannon mentioned earlier, ICWA has long been considered a gold standard for child protection. There's a very heavy emphasis on a lot of things that we generally want to see, like emphasis on keeping kids with their families if they can't be with their parents, and making sure that there's a lot of work done to keep the children with their parents and with their families as a whole. And those are the active efforts provisions. There's also a lot of really important language about notice and involving the tribe and making sure that services and things are culturally appropriate. And so it truly is a gold standard. And if we lose the Indian Child Welfare Act as the Indian Child Welfare Act, putting the parts of it that are very valuable into state law for everybody may be one option. And of course, you know, as mentioned earlier, many of the tribes in Minnesota have tribal courts that do a very good job of addressing child protection and child welfare issues with their families. And so those remain options too. So, So unfortunately, the one area that the revisions to MIFPA will not be able to address is if we have a negative US Supreme Court decision based on equal protection, or saying basically that ICWA is based on a racial status rather than a political status. So at that point, there will be other things that we need to do. And the other issue, I think, with the revisions to MIFPA that we all need to be aware of is that MIFPA only applies in Minnesota. It's Minnesota law. It only applies to cases that happen here. So if, for example, a white Earth family has a problem in Iowa or in Texas, the Minnesota Indian Family Preservation is not going to help at that point. Happily, there is a work group that is being formed to try to develop a model state code so that hopefully across the nation, we will have states passing similar laws that protect Indian families when they're in those particular states. So there's been a group of people working very hard, actually two groups of people working very hard to come up with some language to put MIFPA or to put the Indian Child Welfare Act into Minnesota law. And there's a tribal working group that's been meeting for several months. I think we started meeting immediately after the announcement came out that the US Supreme Court was going to take the decision. And that group is made up of DHS representatives, the ICWA Law Center, tribal attorneys, and tribal social service and child welfare directors. And it's a pretty good group, pretty large group. We don't have everybody participating every time, but I think by and large, we've had participation from just about all of the tribes in Minnesota. And I believe that I forgot actually the ICWA Guardian of Litem program who has been participating as well. So we have a pretty good section of people. We have very carefully walked through both the Indian Child Welfare Act and the Minnesota Indian Family Preservation Act to make sure that we were merging those things together in a way that fits Minnesota law and addresses the issues Then there's another working group. The Legislative Council has drafted an issue that is more based on the BIA regs and has some very strong legislative language. So the two groups are going to get together mid-November and talk about how to go forward and how to have kind of a combined effort. So some of the proposed amendments to the Minnesota Indian Family Preservation Act. One of the things, that has been a struggle, I think, since the passage of ICWA is helping folks or the Guardian program, what areas of the law MIFPA and ICWA are supposed to apply to. So the Indian Child Welfare Act talks about that a foster care placement under the Indian Child Welfare Act is any time that the child is placed out of home and the parents can't get them back simply by asking. And there's a lot of different things that we don't tend to think of as child protection, but where that happens, where kids are placed out of home temporarily and the parents can't get them back simply by asking. There are children's mental health placements, adoptions, third-party and de facto custodian actions, probate actions, and some orders for protection. It isn't anybody's intent. The Indian Child Welfare Act doesn't apply to actions between parents, and there's nothing that we are working on in this group or in the other group that would apply the statute to parents. But we wanted to make sure that it was clear that in absolutely all situations where kids could end up being removed from their parents or Indian custodians, that the laws and the protections of the Indian Child Welfare Act apply. So we added some definitions. We changed the Minnesota Indian Family Preservation Act used the words social service agency quite a bit. And because this statute is intended to be much broader than just child protection, we added child placing agency and made clear in the definition of child placing agency that that does include individuals. So if an individual is bringing a private adoption or is seeking a third party or de facto custodian order, that they're included in this. We also included some definitions for emergency and for serious emotional damage and serious emotional harm. And we added some missing sections, some things that were not in MIFPA but are in ICWA. So we added sections for emergency placement and emergency removal, for right of intervention for the tribe, parents, and Indian custodian, and for placement preferences for Indian children, and some other things that are listed up there too. And then we also worked on kind of tweaking and improving some areas like qualified expert witness testimony. We removed the term enrollment because not all tribes require enrollment, and return of child in voluntary care. So we have some challenges coming up as we go forward trying to get this passed. First of all, as you're probably aware, absolutely everybody's up for re-election on November 8th. And so everybody from the governor to the legislature to the attorney general are all running for office right now. And so we don't know who we're going to have in office. It's really hard to predict what our strategy is going to be as we take this forward. We are likely to have to do a lot of education and convincing of new people and even people who have been around for a while. And so that is concerning, but also presents some opportunities. We also have a challenge because, there are counties and organizations that don't like ICWA, don't want to see it in place, and are not going to be helpful in passing MIFPA and will probably contest it and work against us. So I think we all have an opportunity to educate, and I love when we have opportunities to educate, especially when we get to hear stories about how ICWA has been helpful, and when we get to see healthy families, like we saw earlier tonight with the family that sang for us. I think educating the governor, the legislature, the attorney general, county staff, the public, absolutely everybody that we can come into contact with about why ICWA and MIFPA are so important is going to be a true opportunity and some work. And so I'm glad that we have so many people here paying attention because it's going to take all of us doing this. And also, you know, when we have struggles, we have chances to build new alliances. And so this struggle that we are having with making sure that protections stay in place gives us opportunities to reach out and build some new alliances. So hopefully that will happen too. So what we can do, I don't know, for all of you, I know speaking for myself that when this makes me very alarmed sometimes and scared and sad. And when I'm in that space, the best thing that I can do is I can make a plan. And so based on my plan, here is what I'm asking all of you to take a look at. First of all, take really good care. Take really good care of yourselves, of the people that you love, of the people that are around you, because this is hard. And we need to do this work together and to protect everybody around us. Second, vote, please vote. Vote for people that you believe will be good officials for this issue and for other issues that are important. And take the time to talk with them now. I know we just have a couple weeks now before the election, but now as they're getting ready to run, and certainly after they're elected, talk with them about why this is so important and what you want them to do. Make them feel that pressure from the community that this is important and it needs to stay in place. And then let's plan for the future. Even if we keep ICWA, and even if with the MIFPA revisions, if they go through just fine, there's still a really great future to build and to plan for. And we have a lot of resources and a lot of really good people who are here waiting to make sure that things go forward in a good way. And so let's work together and do that. So that's all I have. Miigwech for listening to me. And if there's any questions, let me know. Thank you.
Well, thank you so much, Rebecca. Lots of information in a consolidated amount of time, but we also have Reanna Jacobs and Cindi Miller here from DHS American Indian Wellbeing Unit, and we're excited to have them here, and I know that they can echo in and chime in on a few other things regarding MIFPA as well. So we're going to hand it over to them now.
Hi, everybody. My name is Cindi Miller. I am a ICWA compliance consultant with DHS, which I have been at for about 4.5 years. And I'm also a member of the Lower Sioux community.
Good evening, everyone. This is Reanna Jacobs, American Indian Wellbeing Unit Manager. And I am also a member with Changshiafe, Lower Sioux Indian Community. Happy to be here. I'm gonna have Cindi start us off. She's kind of like our in-house attorney, and so I love her attorney lingo.
Okay. We were given a list of questions, but first I'd like to start out with a little introduction about the ICWA unit at DHS. We decided to rename the unit to the American Indian Wellbeing Unit, I guess about a month ago. Because we realized that we have a lot more people doing much more than ICWA compliance. I mean, there are 3 of us that do ICWA compliance. We also have, an equity policy consultant who is here today, and several people who work on the initiative tribes. We have a prevention and early intervention consultant, and an ICWA SSIS trainer, an ICWA program consultant, and a human trafficking consultant. So we do a lot more than just ICWA. So we thought now we're name the unit. So that's just a little bit of history about our unit. But I think one of the first questions that was on the list that I received was how will DHS continue to support American Indian families if ICWA is dismantled? We're still going to have grants that we will be available to tribes and other American Indian agencies, such as the Whole Family Systems grants. And there will be the Families First Prevention Services Act in place, which changes the way welfare services are provided in Minnesota. And that, as you know, establishes placement preferences or placement prevention services to strengthen all families. We have also been in communication with the DHS General Counsel's Office to discuss what our options are if what is repealed. And at this point, it's speculative. We obviously do not know what will happen, but we all remain committed to planning as much as we can. And we're getting as many folks at DHS involved in that as possible. The other question that came up was, what protections do families have under MIFPA? And what changes when it stays the same? Again, that's, you know, as you've heard from Rebecca, that's speculative. We don't know what's going to happen, so we can't say. You know, if there are some parts of ICWA that stay, then we can change our system accordingly. If ICWA is thrown out completely, you know, then we're gonna have to start from scratch. But again, it's all speculative and we don't know, and that's the frustrating part. You know, so we just it feels like we have to at some point sit back and wait, but we also want to be planful. And we want to know, like, okay, what are we going to do if this happens? What are we going to do if that happens? So we have to take into consideration everything. And that's kind of tough to do, but we're doing it. And I guess I don't know if I have anything else to add unless, you know, I guess an example would be if all parts of ICWA are repealed, for example, placement preferences on QEW, you know, we'll have to adjust our reviews accordingly. Of course, if everything is thrown out, then I'm not quite sure what we're going to do. But we're trying to plan for everything.
Thank you, Cindi. So just to add to that, you know, if ICWA is repealed, there's still the question about disproportionality in that issue to address. And so we are working around those what ifs and strengthening some of the areas. For instance, you know, Cindi had mentioned earlier about funding for tribal programs. I know there was a mention about tribal courts taking on more of their cases for their children, having their jurisdiction over their children, and that would be for, you know, tribes here in Minnesota, strengthening funding sources to tribes. Another kind of avenue that, you know, we're looking at and working with our other areas like the foster care area, the adoptions area, is strengthening 260C, which is the overarching foster care you know, services when a child goes into out of home placement, and asking for active efforts, those specific active efforts that are outlined in MIFPA to be added potentially to that law. So we are definitely looking at the what ifs and trying to kind of be planful about that. So any questions? So just one more thing I'll add. I know one of the questions is how would DHS change to MIFPA compliance if it was repealed? And so again, that commandeering issue, if ICWA doesn't go away, we definitely have MIFPA embedded already into our compliance process. So it's just really looking at pulling together tribal folks, county folks to shift what those provisions are that we look at for compliance. If ICWA is repealed in its entirety, we would shift definitely looking at continuous quality improvement, strength-based, using that kind of model to really look at the disproportionality and how county agencies are working with our American Indian families. Any questions?
You guys want to continue them together, even if the child or whatever does not qualify for hold, how are you going to keep the family together? Can you guys intervene and kind of help the family get the child recognized to the tribe before the child is taken away and placed to another home?
So, you know, as a state agency, our purview is really looking at county agency work and the preservation of, you know, through their work of families. Again, tribal entities are sovereign, and so we wouldn't necessarily tell a tribe what to do or how to add a child to their, you know, caseload or casework. But I know that many tribes, oh, sorry, the question was, how do we as an agency advocate for children to preserve families to be eligible for tribal membership or eligibility with a tribe? And so the response is we wouldn't necessarily tell a tribe what to do. However, I would say that many tribes are recognizing that already and are changing those tribal requirements. And so I would say it's really about us as a community of Indian people really moving forward with our own tribal communities and bringing those issues to our tribal folks and our tribal leadership. Yes.
I'm gonna be honest, I'm really new to this conversation, but I'm really familiar with DHS from a disability service standpoint. What I'm curious about is how does your division hold counties accountable for lack of consistency in upholding this? Because I know in the disability services, there's zero accountability when counties make errors, and it happens dozens of times a year for every person with a disability.
Sure. So
So I imagine it's the same in your division.
well, so the question was, for those out in virtual land is how does our division or our unit hold a county accountable for compliance? So there's two processes we have currently at the state. One is through the tribal state agreement, which the state has with the 11 tribal nations. And there's a compliance process where families, agencies can submit a complaint of non-compliance. And so the process is reviewing that case and a summary report coming out, an official report, and a corrective action plan requested from the county agency. And then our second process, which is for us, it's not newly instated, but for a lot of folks, it's newly instated. In 2017, there was funding tied to compliance, and it's called the county aid reimbursement. And so this is really the work that Cindi and her team do in terms of reviews of children who are American Indian and in out of home placement. And I'm going to actually let Cindi talk more about her process and that process. But yes, there's funding tied to the secondary review process.
So there's 3 of us who right now are considered reviewers, and we start our reviews around the beginning of February and get done in May, and they're done for the period under review as the year before. And right now, between the 3 of us, we're reviewing about 20% of the ICWA cases, and they're pulled randomly. And so we've developed a tool, and we use this tool. We use other sources that DHS provides, which is SSIS, and we go into the court systems and we review the file. And we just go down the list. We have 6 major provisions that we look at, and we see who's in compliance, who isn't, what areas they need assistance in. We do give them an opportunity to respond at the end of the review in case we can't find something or something doesn't make sense. And then we move on to the next one. So at the end of the review period, it takes about 4 months. Then we come up with some statistics about how well compliance has been for that particular period under review. So far, when we started in 2017, we did a baseline review because we've never done that before. And I think the state was at 49%, 42%. And this last year, it was up to 85%. So it is getting better. But of course, we don't have the personnel to review every single ICWA case in the state. I mean, that would take many more people than 3 people. You know, so because it's not, you know, you can just look at this file and get it done in an hour. It takes quite a bit longer than that, because you want to do as much investigation as you can. So that's what the compliance process is right now for ICWA cases in Minnesota. Oh, and then we also have a if the county is out of compliance for 2 years in a row, then they have to do a protective action or protective action plan. Okay. And so we help them get into compliance. We provide training to the counties if they want, and most of them do. And we put on, I don't know, maybe last year it was kind of low because of COVID, but the year before, you know, we did like 40 to 50 trainings, either virtual or all over this, you know, in person. So that's why I think the compliance rate has continued to go up, but we still got a ways to go, you know, because there are some counties that still need help, to be honest. Oh.
Are you randomly or are they told by some county personnel prior to for your
They're randomly pulled.
by DHS?
Oh, she wanted it.
I'm sorry, you guys down.
What was that?
How are they selected for review?
How, she wants to know how they're selected for review. They're randomly pulled by our research and development department. And so we're not the ones pulling the case.
Like out of a database then of names
Yes.
of current cases, or are those closed cases or current cases?
They're cases that were open for the period under review where the child was not a home placement.
And then what percentage should you say if the county was out of compliance, what was the threshold, or if they're out of compliance 2 years running, that they have a correction action plan?
Well,
I missed that.
Right now, right now they have to be 100% in compliance.
The 100. Okay,
Yes.
thank you.
Are we done? Okay. We're stuck.
Technical difficulty. Thank you so much. I know that it is a short period of time that we have each presenter. There is Q&A session. We won't get to every single question. We're trying, if you see us right now and you see us picking up our phones, we're combining questions that are similar so that we can get to as many as possible. So I know it's hard to just sit back. We encourage you to write your question down just because there is a lot of information that we want to get out and we want to answer as many questions as we can. Anything that we don't get to online today, we will still provide answers for, and we can do some of that with an email. Or if you have a very specific question on a case, we will get you resources to try to answer that question. We're just pausing for just a brief moment. There they are. We have slides for the Guardian at Litem program, ICWA division. They're next up here on our list. It's Lynn Braveheart and Jody Alholinna, the ICWA Guardian at Litem program, just to talk a little bit about the Indian Child Welfare Act, Guardian ad Litems, and their program. So I'm going to turn it over to you now. Thank you.
Bujuhan Mitakiapi. My name is Lynn Braveheart. I'm Oglala Lakota from Pine Ridge, South Dakota, and I'm the State ICWA Division Program Manager for the Guardian ad Litem program for the state of Minnesota. And I'll let Jody introduce herself.
Good evening, everyone. Thank you for inviting us. My name is Jody Alholinna. I'm an attorney. I practice juvenile and family law for 25 or 26 years, and both in state court and tribal court. And I'm the staff attorney for the ICWA division of the Minnesota Guardian ad Litem program.
So I just want to share a bit of my story so you know who I am. I used to work at MIWRC, so it's really nice to be back here. I used to work in the housing program. I've been at ICWA Guardian ad Litem previous to being the manager for about 11 years. And I just wanted to recognize that Robin Bradshaw and her granddaughter are here. And so I'm so happy to see them. part of the reason why we began an ICWA division is because of their case. And how we saw the need that we needed to change things. We need to create systemic change and hold ourselves accountable as the Guardian Ad Litem program to do what's best for Indian families. So I'm just going to start out there, and we'll move to the next slide and talk a little bit about how we're doing that.
Okay, I might blow your ears out. So I think probably most of you in this room have heard of Guardians Ad Litem or worked with them. But for those of you who maybe haven't, kind of, what is a Guardian Ad Litem? And a Guardian Ad Litem is appointed by the court to advocate for the best interests of a child only within the context of a court proceeding. And Guardians Ad Litem are, they're not legal guardians for the child. They only advocate for the best interests. They can't make legal decisions for the children for whom they're appointed to represent. They make recommendations to the court. Sometimes the court will adopt those recommendations and take those recommendations and put them into an order. So then they become legally binding, but an individual Guardian Ad Litem does not have the legal ability to make decisions for children. And the reason that there are Guardians Ad Litem appointed in cases is because there's a federal law that says whenever there's a judicial proceeding involving a child who, where there are credible allegations of abuse or neglect, the law mandates the appointment of a Guardian Ad Litem in all 50 states. Some tribal courts also have Guardians Ad Litem. They do that under their own code. They're not required to have Guardians Ad Litem.
Next slide.
Next slide. And then just briefly up there on the screen, if you can see it, those are the statutory Minnesota law sets forth requirements that each Guardian Ad Litem is required to do in every case. So they're required to conduct an independent investigation, advocate for the child's best interest during the course of the proceeding, maintain confidentiality of information related to the case, monitor the child's best interest throughout the proceeding, and then present written court reports that need to be provided to the parties and to the court. Next slide.
So the Guardian Ad Litem program created an ICWA initiative in 2018, and this was to work on the equitable, I can say that easy, systems change, so that this would positively affect Indian children that are placed in out-of-home placement higher than any other state in the country. We're talking more than 16 times their white children. And so we had huge concerns about this. So we created an ICWA liaison position, and we started to work on a strategic plan, and we can move to the next slide. Okay. So in 2020, we began working on a strategic plan with Indigenous Collaboration. They're an Indigenous organization that helps folks do strategic planning. We created an ICWA, a division mission statement and a vision statement and mission statement. And we also developed a 2-year implementation plan and a 10-year strategic plan. We can go to the next one, please. So our mission statewide is that we are committed to advocating for the best interests of American Indian children by persistently applying ICWA and MIFPA to preserve American Indian families and culture. All right, so when we created the ICWA division, sorry, we're kind of flying through this because we don't have a lot of time. We knew it had to be statewide. In Hennepin County, we did have ICWA specific Guardian Ad Litems, but not across the state. So what we did in the last 2 years is create positions for ICWA coordinators, who are really the supervisors that are in each one of the districts in Minnesota. We created positions for ICWA Guardians Ad Litem that will cover every case in Minnesota. We're currently hiring. There's jobs on the website. If anybody's looking for a job, we just increased the pay up a couple bucks. So we are hiring.
Can I interrupt? So there are some ICWA Guardians Ad Litem in the room right now. Can you raise your hands? And if anyone is interested, talk to them. They'd be happy to talk to you about it.
I'm also very proud that most of our ICWA guardian ad litems, we're about 99% all native. Like we are enrolled members of our tribes and members of our tribes in and from Minnesota. So that's really great. We wanted that because we need that cultural competency, and Native people are inherently aware of the sovereign and political status and what the child welfare system has done to Native folks through genocide and Indian Adoption Project and removal. So we also realized we needed a staff attorney, and I had seen Jody just, you know, as an expert in ICWA with empathy and compassion and the knowledge of tribes in Minnesota. And so we asked her to come aboard a couple of years ago too. We also had a case consult that you developed, and then you can talk about the policy manual.
Oh, okay. So just those numbers up there on the state of Minnesota, those are judicial districts. So Minnesota is divided into 10 judicial districts. So as through the initiative process and strategic planning, there was like a 10-year plan that was developed. And Lynn has completed like 90% of it in 2 years. So yeah. She's a strong advocate for our families. As part of our division, we developed a policies and procedures manual. It's, yeah, I don't know, it's like 122 pages. And it's used to guide not only our ICWA guardians ad litem, but anyone who has a case that ICWA to, if a guardian ad litem case, they're supposed to be reading the manual, applying it, and there are potential employment sanctions if they violate, if a guardian ad litem violates a policy or procedure of the ICWA division. So there, you can maybe go to the next slide. This is just an overview of the manual, kind of what it goes through. You can go to the next slide. Part of my role in the ICWA division is to provide legal consults to guardians ad litem around the state. Sometimes I have judges contacting me, sometimes I have court administrators contacting me. Because of the awareness work that everyone in this room is doing, more and more people are aware that ICWA exists. And they're not always sure when it applies or how it applies, but they're asking questions. So keep doing what you're doing. The Guardian Ad Litem program acknowledges that, as Lynn said, that we could do better for our Indian children and our Indian families. And part of that is, as Lynn indicated, is having ICWA specific guardians ad litem and having expectations that our guardians ad litem will be in the community, working hand in hand with families and tribes. I can't promise that we will always share the same perspective, but I would like to be able to promise that there is an expectation that every family, every child, every parent, every tribe will be treated with respect as a partner. Some additional things that the Guardian program is doing to help support ICWA. I think, as maybe Karl had stated, that and helped prepare and signed on to an amicus brief or friend of the court brief in support of ICWA at the U.S. Supreme Court. We are working and supporting amendments to the Minnesota Indian Family Preservation Act, as well as the Tribal State Agreement, to strengthen Indian families and children and communities. And we're not taking the lead on that. We're working in partnership. And then you're all invited. I tried to, I'm very technically challenged. I tried to embed the input into the PowerPoint. I couldn't figure out how to do it. But if you don't have it, we'll try to get around a flyer. Everyone is invited. The Guardian Ad Litem program is hosting a virtual listening session on November 9th for the Brackeen oral arguments. They will be live streamed by audio. Unfortunately, there's not going to be video available. And then we're providing a lunch afterward. And so we would love to see many people from the community there. It's going to be held at the in the basement level of the Hennepin County Juvenile Justice Center.
I think we might be out of time, but we are doing things with advisory council, presenting to MIAC. We've done evaluations, and I would, like I said before, the Clifford Bradshaw case was my case eventually once the case turned to ICWA, and I was appalled at what the Guardian Ad Litem program did to this family. It's the reason why it's at the Supreme Court, and I'm just going to share that I protested that they would be. I protested. I wanted the Guardian Ad Litem removed, and that I said this case needs an ICWA guardian. We're trained, we're specialized to work on these cases, and they refused to remove her. And I said that if you don't, this case has the potential to go up to the Supreme Court, and it could overturn ICWA. And I wasn't listened to, but eventually I was, and it was after, the Judge Wilms issued her, her decision on the case, which, gave Paris back to her grandmother, and which was a victory. It's a complete victory, but it's also a complete tragedy that it ever needed to happen. And we're fighting the racism that still exists in the child welfare system every day. There was just a case yesterday up north, or a couple of days ago, where a mother did everything on her case plan, and at the table you have the child social worker, you have the county attorney, you have the Guardian Ad Litem, you have the tribe. Everybody at the table was in agreement that they should reunify and close the case that day because the mom did every single thing on her case plan and the judge refused to close it. This happens, these sorts of things are happening all over the state. And that's why we are gearing up and training our ICWA guardians to be the experts in the court, to be the ones that intervene and hold everyone accountable. And they're brave. And they're brave. And I grew up with my mom being in the Indian Adoption Project, and I aged out of foster care. I lived at Young Center when it was as a shelter kid. So I'm very passionate about this, and we're going to keep persevering. So thank you for listening, everyone.
We do have a couple questions for you. One, could you talk a little bit more about the training and certification partnership? Is that?
Yeah, sure. Do you want to talk about your?
Yeah, so I'm a graduate of UMD as an ICWA scholar, and so University of Minnesota Duluth has a tribal training and certification partnership that was started by Bree Bussey and Jerry Jaskins, and there's some very strong Native women who are educated, and they're running that program up there, and they helped us create a 4-day ICWA MIFPA Foundations course for Guardian Ad Litem work. And you have to go through that course in order to even take a case in the Guardian Ad Litem program. So it goes over the historical context of what happened to Indigenous people on this continent. It goes through the legal, we really drive home what MIFPA is, what ICWA is, what placement preferences are, what is a qualified expert witness, and there's 5 areas that we really train our guardians on, and that's kind of how they get certified. And we have had other, non-native or non-ICWA guardians that have gone through the training, and it's been life-changing for them. We do things like the Minnesota blanket exercise, and I don't know if you've heard about that, but Enda Young was the one that I think created that curriculum. And it's an experiential exercise where you're standing on blankets, and it's telling the history of tribes in Minnesota and what's in its narrative. So you're getting your land taken away, and you're getting your children taken away, or you're getting removed to boarding school, or some of you die and you have to go sit down. And by the end of it, everybody is really shook. And then we have Sandy Whitehawk, our elder, come in, and we process those feelings. And some of the folks who come to our training cry and have a lot of feelings because they've never seen this before. They're like, I live 5 minutes from the reservation and no one's ever told me this. And it's an injustice that nobody knows about our history. even you're living, 5 miles away. So that's how we get certified. And it's a beautiful training. Encourage people who want to maybe go if we have room. We would be open to that. And what's the other question?
The other question.
The other question is, are there any statistics that show the differences guardians ad litem of family, like a family court, make in the court? So like an example would be like, Minnesota versus another state that maybe doesn't have something like what we have in Minnesota. Is there any kind of data that shows what difference this kind of programming makes?
So we're so new and we are working on data and trying to use our own database system to generate data for us. Right now, we only have anecdotal stories such as Maya, who is an ICWA guardian in the 6th district. She's been working on ICWA cases for, I think, a couple years now, and all of her cases have closed in successful reunification except 2 cases. And Gabe Wakanabo, who works up in Beltrami County, he's constantly requested by judges, even though he has a really high caseload. He's requested because of his cultural competency and his ability to make sure the families are getting the active efforts they deserve and that they're reunifying with their children. And one of our goals for family preservation is not removing kids at all, if at all possible, that we're safety planning first. We're understanding what is an emergency, what is serious emotional damage and harm. How can we safety plan around it with uncles and aunties and cousins and grandpas that can come in and take care of these kids, because every time we remove an Indian child, that's another ACE. Yeah. That's another trauma. It's better for kids to stay within their family than to be removed to a stranger's house. So, and that's the science right now. So no, we don't have any actual numbers. We have a lot of stories.
Right. But wonderful stories of reunification, and thank you so much for coming and speaking with us all. Just want to give a hand to all of our presenters tonight, and then we're going to move into some Q&A. We do have a couple of questions that were on Zoom that we're going to just ask to our group here. It's really actually just the one question right now. So if any of you want to take this, or I can, what can counties do to build relationships with tribes? We know that tribal workers are working really hard, and we want to support a collaboration.
Yes, I could answer this question.
Go ahead.
So I did my master's internship with Red Lake Nation, and then I ended up working there for another year. But so I got to work statewide and actually nationwide on ICWA cases. And social workers could actually read ICWA and MIFPA. That would be the first thing that they could do. Just read it, know how to provide notice, get the names and the birth dates of the kids right, so that when we send that eligibility into our system, that it spits out the correct information, because we want to get those active efforts and those ICWA applies at the beginning of a case when it says they have Native heritage. It starts from there, and that's when we're actively, we just don't just fill out the paperwork and like, yeah, there it goes. You have to be active, rigorously paying attention to that case. And yeah, so
So as a family services director at the Minneapolis American Indian Center, but also someone who was a tribal rep and a tribal liaison for many years, I mean, I think one of the big things that counties and county social workers can do in building relationships is to just make and put forth the effort to get to know individuals, actually go to the tribal offices, know what services are available at the tribe. If a tribe is, quite a long distance away, we have so much technology now. We have Zoom, we have every kind of platform under the sun, and folks are getting more used to using them just to communicate with one another. So many times I get called and folks tell me they can't get a hold of a certain tribe, and I find out they've only ever tried to email, and the email address that they have isn't even correct. They've never picked up a phone. They've never left a message. And so these things are what we call active efforts, and it takes more than just, you have to get to know people. You have to get to know what their workload is. How do they work best? What's the best way to reach people? Many of our tribal representatives and liaisons, especially outside the state of Minnesota, have very underfunded programs. There's maybe one Indian child welfare person to an office, and they're serving the entire United States of America. So it's up to the counties to put forth a larger effort, because the tribes, are historically funded and don't have all those. So that's what I have to say about that, I guess. Other questions? Someone in the room. Okay. Do you mind coming up over here to the mic? Then that way we don't have to repeat it, because it's hard sometimes to get it right when you have to paraphrase. And you don't have to be on camera. You can stand off to the side if you want.
Just right on in. Okay, great. Thank you. Move a little bit over than that. Yeah. Oh, she blocked it, so
You're good.
am I on the way?
Nope. You're good.
You're good.
Go ahead.
Okay, I just wanted to know that, in today's world, or, our communities, we have a lot of, mixed children that get caught up in the system, and that I'd like to know if there's other active, efforts into actually finding if those mixed children are Native American, if they're not, if their skin color, or if they don't look like they're Native American.
We train our ICWA guardians when they're at an EPC. So the EPC is that hearing when the court is looking at removal. That's when inquiry and starts about inquiry starts at the first phone call when social workers call, or when someone calls and makes a report, child protection report. Inquiry should be starting then at the very beginning. But sometimes inquiry isn't done rigorously or with active efforts. So even if a child doesn't look, I don't even like what that sounds like, because my son is very light skinned, and I myself am a very light skinned Native person, but a lot of folks in my tribe look like this. So I think that if a family says they have Native heritage, it's incumbent upon us because of the law to look and I think a lot of times counties do one kind of kinship study, and then we don't sometimes get to see it, but now they have to show it to us. And sometimes when we look at it, we go, well, I recognize that person's name, or I know that last name is from Leech Lake or whatever. And so then we can get connected and you have to get connected to the tribal workers too. Because there's a lot of kiddos that are out there and families that don't fit the stereotype that white people have of us, of what we should look like.
And if the family doesn't know or the child doesn't know, it is still absolutely the responsibility of everyone involved in the case to ask the tribe and provide notice. So we don't have to make that, we don't have to have the information, we don't have to make that kind of determination, but we have to ask the people or provide the information to people that do know and can make that decision. So part of active efforts is asking the questions, part of active efforts is providing the notice. And if it ultimately ends up that a child's not, and notice was provided and active efforts were provided, that's okay. And so asking and providing notice are absolutely critical and required by the law.
So is it absolutely by the law? So when you're in that courtroom, the someone say, hey, did you look in and make sure that they looked into if there's Native heritage? Like, where's the accountability to make sure it's actually happening?
The question is, is there someone in the courtroom or something that is asking, did we look into Native heritage? I can try to answer this. So at the Minneapolis American Indian Center, one of the things we did at one point is we had a nationwide project where we came up with a court checklist that is a model for judges to ask. And that is one of the questions, because what we found in the research is that if you're asking that question on the record, you're more likely to then make sure that if it is an ICWA case, that it, continues ICWA, or that it's fully explored, or that, eligibility for the children is determined. So that's one thing. There are court monitors in Minnesota in the urban area. So in Ramsey County and Hennepin, and then the surrounding metro areas. And that's one of the questions on their checklist, to see, did the judge or someone else in the courtroom ask that question? Or is there some other reason to believe that this could be an ICWA case? And those things are reported on and then shared so that they could be looked at, that data in the future, to see if, there are times when that's not being reported. Now, that's not the answer to all of it, but that's just one way that it could be looked at. We'll go to you next. I have just one more question that came from online. What impact will there be on urban American Indians and the urban American Indian population if ICWA is found unconstitutional?
So with that question, I think one of the really important things to know in regards to ICWA is that ICWA applies to all Indian children, and Indian children is a child that's eligible for membership in a tribe, regardless of where they live. So if it's a state court proceeding, so if there's a state court making a decision about a child custody proceeding involving an Indian child, ICWA is going to apply. So whether or not you're in the urban area or not, ICWA does not apply in tribal court because tribes as sovereign nations have their own child welfare code that will apply in tribal court. But as far as ICWA, if you're in a state court, it doesn't matter if you're in the urban area or if you're living in a county that is it borders a reservation. ICWA is going to apply. So if ICWA is found unconstitutional, it's going to impact all children, Indian children in state court proceedings everywhere. So.
Okay, and we have a question from the audience. If you want to just say your question and then we can repeat it, or you can come to the mic, either way. Okay. That's fine. Yeah, you could stand to the side too if you want.
I am curious how do parents that they know they have tribal and the county and the tribe knew, and we're taking advantage of the situation because they knew it was being victimized at the time. How do you advocate as a parent for your equal rights when you're in the middle of a terroristic situation, even before you get to court? Because oftentimes you don't want to get to court, right?
So I'm going to try to paraphrase the question a little bit, so please correct me if I get this wrong, but there's a person speaking that is a descendant who had gone through a child protection investigation, and help me out here, but I think that she's asking, how do you, what rights do you have? How do you, I guess, lessen a terroristic type feeling of being investigated? I'm having a hard time paraphrasing the whole thing. Okay. How do you advocate for yourself in that situation, and how do you make sure that your family is protected before you get to court? Thank you. Sorry, I'm going as we actually have our. You can certainly answer the question.
Yeah, Jill.
Jill Esch is here. She is the ombudsperson for American Indian families for the state of Minnesota. So she's gonna answer that one for us.
Aloha, everyone. I actually have one of my board members here. So I'm the ombudsperson with the Office of Ombudspersons for American Indian Families, the only independent state agency of its kind in the nation. We just opened our doors last year and just moved into our space at the ending of May. I have my cards here and my recent reports, so you can reach out to me. One of the things that is really important is for families to understand what their rights are. And I can provide information and resources. I cannot advocate for you, but you can educate your attorney, or you could go to the law schools to see if there could be like a certified student attorney to assist you with it. I've also worked on the case. That is, I call her Grandma Robin, and she was absolutely just amazing. She would call me. I couldn't advocate for her. The case was a non-ICWA case, but it was regarding an American Indian child. And I said, Grandma, you need to look at your Indian heritage to see if you have more Indian blood. She would continue to do that and continue to do that. And she would call and say, Jill, I found more blood. Grandma, contact the tribe. Grandma, contact the tribe. And I still remember her calling me and said, they recalibrated my blood and we got enough blood. And so for that case, the court actually found that the guardian ad litem was biased. I sat through almost all 5 days of hearings for that case. But it's really important for the families to understand what their rights are and how to research. I have provided information and resources where grandmas have come to me and told me that there was a mathematical miscalculation and they actually have more blood, and therefore the grandchildren then were placed with her. So it's really, really important for everybody to understand what your rights are. We have our resources on our website. And I must say, it is a beautiful website. We really work on that card. We have what we call a native image. And when you look at this, you can tell that we work with American Indian families. I don't just work on cases where the children are eligible for membership or enrolled. If someone tells me that this child is American Indian, then I can work on that case. I may not be able to pound my ICWA hammer at that time, but when you get grandmas involved, grandmas really do what needs to happen. And they will contact families. They will research. They will do what needs to happen to help protect. But I am not alone. There's a lot of circles in this room. These people are part of the circles that I work with. So please reach out. I'll leave my contact information on the table over there. But we really need to get the parents involved. Once parents understand what needs to happen, especially fathers. Fathers have almost no rights and very little, if any, resources. So we can get the fathers involved and we can get the moms doing what needs to happen. The children are future. You saw as to what happened this evening with that. I mean, 75,000, they said, as to followers with it. So I really want to thank everybody that's here. Together, we can do it, but it takes all of us. It's like what Matt Thornhill said a number of years ago. We think outside of the circle to bring them into the circle to strengthen the circle. And I said, Matt, I like that. And then let's duplicate the circle. So together we can, because we have to. Thank you.
Glitch. We are at time, folks. I know folks might have other questions. We are at time to turn off our live and our webinar. But I don't think there's any of us here that are like racing right out the door. So please feel free to come up and talk to any of our panelists. Thank you all so much, Miigwech, for coming. We are the Metro Urban Indian Directors Family Preservation Subcommittee. I want to thank all of our committee members for all of their hard work in putting this together. It takes a team of lots of our American Indian nonprofits to do this work and to provide these types of trainings. And we would love, love, love to see more community members. If you want to get involved and come to our meetings, one of the individuals who asked the question, she's been involved in some of our meetings. We would love to have more folks just come and share their voices. So if you would like to do that, see me afterwards and I'd be happy to talk with you. Thanks again and good night.